Okay, well, hello and welcome to our April monthly quarterly webinar. My name's Alex. I am the co-founder of Sprintlaw, and today we're going to be talking about contract red flags. Before I get into the content for today, just a quick introduction to Sprintlaw for those who are not already clients of ours. We're an online legal service for small businesses and startups. We mostly provide fixed price legal services for smaller businesses, covering most areas of business law from business setup to terms and conditions for your website, intellectual property protection, data and privacy, employment law. If you're raising funding, we can help with the contracts for that. Pretty much any area of law that you might find yourself in need of help with as a business. We provide fixed price services. None of our services are done sort of by the hour. So it's all very upfront and transparent pricing. We have an optional membership, but the majority of our clients sign up to it too. For a low annual fee, you get access to discounts on our services, as well as a growing set of tools, including an ability to make some free legal documents, a DocuSign style e-signatures tool, Taylor AI, our legal AI tool, and you also get unlimited quick consults with our lawyers, which can be a very useful feature. So if you are not already a member, do consider signing up. We've been around in the UK since about 2020. We are, as you can probably tell from my accent, headquartered and originally from Australia, but UK is becoming our biggest market. And we have a bit over 8,000 clients, a team of over 50, and we're also in New Zealand as well. So for those that need advice in other markets, we can help with that too. Also, just wanted to call out, we've recently released a free website scanning tool at scan.sprintlaw.co. So if you want to check it out, feel free to head over to that URL, put in your website, and it will use some technology that we've created to analyze your website and let you know whether there are any either GDPR or privacy issues or other sorts of legal issues on your website. So check that out. It's brand new. And if after this webinar you are gripped by the inexplicable need to get some advice on contracts, we have free consults where we are very happy to have a chat with you. So again, we'll drop a link to get in touch, but just feel free to reach out to the team if you need help with any of that. So into the content for today, we're going to be talking about contracts, starting with really the basics. What is a contract in a legal sense? Why might you want to get a contract in writing? We'll go through sort of how to read a contract, what the different concepts are in a contract, if you're handed one, how you can navigate the document, and what's important to focus on. And then we'll go through, sort of zoom into a bunch of common clauses that you'd see in a contract, and help you understand the things that you might want to look out for if you are, again, given a contract or have written a contract. So we'll look at things like payment clauses, scope clauses, IP clauses, restraints or restrictive covenants, GDPR and data protection clauses, termination and liability clauses. As I'm going through, Zoom has a Q&A feature. Do feel free to drop questions along the way. We might have a bit of extra time at the end, so I'll answer any questions I don't get to then, but I don't mind answering as we go as well. It always helps add color to some of what I'm talking about. So let's kick off. So what is a contract? Well, for anyone who goes to law school, in Contracts 101, they teach us that there are four elements to a contract in a legal sense. You have to have offer, so someone has to offer something to someone else, acceptance and acceptance of that very offer. You need consideration, which is a legal term for some sort of quid pro quo. So I'm doing this for you and you're doing this for me. Usually that could be just payment. I'll do this for you in exchange for payment. So that we call that consideration, but there may be, I'll do this for you and you do this for me, payment in kind or in another sense. So you need offer, acceptance, consideration, and you need an intention to create legal relations. If you're just joking around, it may not be a legal contract, but it has to be clear that both parties intended to create sort of formal legal relations. So those are kind of the elements of a contract. Now, we've got an example. Alex offers to sell a car to Taylor for £3,000. Taylor accepts the offer. At the time that they made the deal, both parties evidently intended to create a legally binding agreement. So very, very simple example. but that would be the elements of a contract. We've got the offer to sell the car, an acceptance consideration, the £3,000, and then a seriousness to um, the sort of transaction. You'll notice a couple of things. First, you'll notice there's nothing in there that says must be in writing. So that's not a requirement for there to be a contract at law. You don't need it to be signed or evidenced in writing. It's a good idea to, and we'll go through that in a second as to why. But you can have an oral contract or a contract created over email, et cetera, et cetera. In legal terms, these are the sort of key four elements. And for those of you that are thinking, what happens if someone just does something for someone else for no consideration? I promise to do this thing for you for free. It was interesting for me to learn in law school that that, in fact, is a barrier to there being a contract. If somebody offers to do something for you for no consideration, you may not be able to show that a legally binding contract exists. Now, there are these things called deeds, which are a different kind of contractual style arrangement, which must be recorded in writing and must have a witness. And one of the elements of a deed is that it doesn't require consideration. So oftentimes, if you're offering or someone's offering to do something for you for no consideration, and it's really important to you that it actually gets done because maybe you're relying on it, lawyers will often advise you, well, hey, you can't actually just use a normal contract. You should get that in a deed. So a tiny little quirk of law, but I think important to point out that in the general sense that there has to be two sides to a contract for it to be legally binding. So I said you don't need to have the contract in writing. It is still a very good idea. And lawyers will always advise you for any important contract that you do, any transaction you enter into, to get it in writing. First of all, it just makes it clear that there is a contract. There's no argument about whether or not there was one. The contract in writing will often say quite clearly, party A offers to do this, party B accepts that offer. The consideration is this payment, and we intend to be bound by this agreement. So it will tick off the four elements, and when it's signed, we'll know that exactly what's being agreed and that the elements of the contract are met. It's proof, stops one party saying, no, there was never an agreement. It's professional to have proper agreements, and particularly if you're working with customers, it can sort of look good to be organized and have proper written contracts and help build a professional relationship. Contracts, when they're in writing, can be more comprehensive. If you just agreed to sell your car with a handshake agreement, it might be unclear what happens if there's an issue with the car, what happens if the motor breaks, what happens if the £3,000 was meant to be bank transferred, but it doesn't come for 3 weeks. If you don't have all of those scenarios in writing, it can lead to an issue or a dispute. And again, when you have it in writing, you can cover all of those different circumstances. And some, now I said in general, you don't need a contract in writing. Some specific types of contracts, for example, if you're selling property or entering into a long-term lease or providing consumer credit, there are other laws or specific laws in the UK that sometimes do require things to be in writing. So it's the general position that it's not required to be in writing, but again, in certain circumstances, you may actually need to, if that makes sense. So in business, you will often be out there making all kinds of deals, signing up to all kinds of arrangements, and agreeing things with various people. And one thing, if you're running a business, to be considering is, well, when do I need to get a proper written contract for this arrangement? People talk a lot in business about handshake agreements, good faith agreements. People often, in certain circumstances, don't like to put things in writing because it may overly formalize a relationship. Different lawyers will say different things, and the most risk-averse lawyer would say anytime you're taking on risk or relying on something, just get it in writing. My view, particularly for smaller businesses, is you don't necessarily need to spend the time, money, effort getting every single arrangement in your business properly recorded in writing, because if that's all you spent your time doing, you wouldn't have time to run your business. So what you want to be thinking about for different arrangements you make is, how important is this arrangement, and is it worth formalizing? And I think using a simple 2x2 risk matrix is a good way of thinking about it. If it's a very important deal, and if it's very possible something could go wrong, you really want to make sure that you've got a written contract for it. If it's a one-off thing with very low risk attached, you may not necessarily need a contract. So, for example, if you are thinking about your customer agreement, but let's say you're a website designer building websites for a client, you're going to be your business involves taking on lots of clients and signing them up to make a website. If you don't have a contract, chances are one day with one customer, something's going to go wrong. The probability of something going wrong is pretty high, and it could be pretty severe if you make a website for someone, the website goes down, it causes their business all kind of losses, and they decide to sue you and there's no contract. It could be quite a severe risk for you. So if I'm speaking to a web designer, I'll often say to them, one of your most important contracts is your customer contract because it's the one thing that's probably going to be tested. Now, if the web designer, or let's say a web design agency, has invited a guest speaker to come into the office for a day, they could do a contract. I'm paying you this much money to come into the office and speak to my team. You promise that you will present information in a safe way, and you won't hold us liable if you get injured during your presentation. You could do a contract for that, but really, depending on what this person's doing, the probability of something going wrong is probably pretty low. And even if it did, it may not be business ending for you. So you might not bother with a contract in that circumstance. So, I mean, those are two very easy examples, but there's obviously a whole spectrum in between. And I think it's useful to think through this lens. We often have clients calling us saying, should I get a contract? And, we as lawyers will ask these questions. Well, how important is this? How likely is it that something will go wrong? And how critical is this deal? But for things more in the orange and the red sections, you definitely want to be thinking about formalizing. So if you are handed a contract or given a contract or trying to review a contract, if you're not a lawyer, it may look a little bit like gibberish because there's lots and lots of formal terms littered throughout the document. Lawyers become very well trained in how to read contracts, particularly contract lawyers. And one thing that I often reflect on is, when I'm reading a novel, I'm going to read every word and read it from beginning to end. When I'm looking at a contract, I'm seeing a structured document. I'm actually thinking, okay, this is the names of the parties are going to be up the front. There's going to be some definitions down the back. There's going to be confidentiality clauses around the middle. And so it's a very different experience to reading a book or an article, if that makes sense. And so when you're handed a contract, thinking of it as a structured document, I think, can really help you unlock what you should be looking for. So to start with the very basic contracts, written contracts pretty much always will have a section defining who the parties are, who is the person that's making the offer and who's accepting it. Or maybe there's offers and acceptances back and forth in a more sophisticated contract, but who are the people who this is going to bind? And there's a way that we usually identify them. You want to have it be clear enough so that somebody who picks up the document will be able to identify who this contract is between. So usually for a company, we'll have the company's name, explain which country they're incorporated in, and provide their address. And if they have a registration number, we'll include that there too. So it's pretty clear who it is. We then have the definitions section. So definitions in a contract are these sort of capitalized terms, which anyone who's looked at a contract would notice when you're reading through the body of a contract. Certain words have sort of capital letters. Words that appear normal are uppercased or in proper case. Whenever that happens in a contract, that signals that this is a defined term. And usually at the beginning or at the end of a contract, there's a definition section. And so, for example, you can see here, part of a contract might say this client may terminate the agreement for convenience at any time by providing 20 capital B business, capital D days written notice to the service provider. Because the term business days has been capitalized, we can go over the definitions and say, see, business days means a day that's not Saturday, Sunday, or any other day, which is a public holiday or bank holiday in the place where an act is to be performed or a payment is to be made. So lawyers use definitions to be very specific about what otherwise ambiguous terms would mean. If this did not have a definition, what if it was a public holiday? Is that considered a business day or is it not, et cetera, et cetera? And what state or country are we talking about when we say public holidays? So that the definition helps remove that ambiguity. And you can see there's other definitions here that do the same thing. So very important when a lawyer is reading a contract, we'll often have the definitions open in one hand or on one screen if we're doing it on our computer, and the clause open on the other, and we'll sort of be cross-checking what the different terms mean. So we've got the parties, we've got the definitions, then we have the terms, which are the main part of the agreement, which actually says who's doing what. And they'll say this agreement starts on this day, this person will do this person agrees to do that. We'll go into that in a bit more detail. And then sometimes at the end of a contract, we'll have schedules, or sometimes at the beginning as well. And the schedules will often be commercial information, which is referred to in the terms, but is set out at the back, so someone can, from a quick glance, kind of see what this contract is about, if that makes sense. So we have, for example, a schedule from a supply agreement. So the contract might say, the supplier agrees to provide the goods in Schedule 3 to the customer. And you read that in the terms and you say, okay, what's in Schedule 3? You hop on over to Schedule 3 and there's a big list of what's actually being supplied. So again, you don't have to do that. A lawyer could put inside the clause, the supplier agrees to provide A, laptops, B, office chairs, C, desk lamps, D, printers. But if there's a lot of things being supplied, it's much easier to read if it's just set apart in a schedule. And so a lot of what contract lawyers are doing is not only writing things that are legally enforceable, but trying to find a way to structure the document so it's easy to understand what's going on for anyone that needs to read it. So schedules are usually just sort of attachments to a contract. And then at the end, we have our signatures. So the signatures block is obviously people know what that is, a place where you would sign and date the agreement. There's certain signature blocks that need to be used for companies that may be different to those used for individuals. And when I say need to be used, written signatures for most contracts, not all, are not required. I mean, as I said earlier, in fact, it being in writing at all is not required. So having a signature is a really good idea as evidence that it was agreed to, as evidence that both parties agreed to all the terms and conditions and they knew what they were entering into. You're ticking those 4 components I mentioned earlier. And there are some laws that say, whilst you don't need to have this contract signed, if it's signed in this particular way, we will give it extra evidentiary weight. So it's a very good idea to get things signed, and particularly for those important top right corner sort of legal contracts, you should get them signed. But we have on the other side of the screen acceptance by ticking a box, which many people will have obviously done that online a lot. That's also a valid way to form a legal contract. It doesn't have to be signed. The evidentiary weight on a tick box terms and conditions is lower. Someone could argue, I clicked on the terms and condition, it didn't work. I didn't actually read it. That wasn't me that ticked the box. So if you are using a tick box acceptance, there's potentially a risk that someone argues that they're not bound legally. They didn't know what they were signing, or there's no proof that they ever clicked the button. So there's risk attached to that. But provided you can establish that the party did click the button and tick the box, you would have a valid legal contract that you can enforce as if it was signed as well. So it is very much a valid way to form a contract. And again, for ease, a lot of people use the tick box acceptance rather than the formal signed contract. But for critically important documents, lawyers would always suggest that don't have any doubt, get it signed properly. We also have these browse wrap terms, which people might have, I don't know if people have spent time clicking into the terms and conditions on websites, something I love to do in my pastime. But if you read terms and conditions of many websites, they say things like accessing or using this website constitutes acceptance of these terms. This is a little bit gray. So, as I said before, you don't need a signature um, for a contract to be formed. You just need those four elements we covered. And there is uh, some law that allows acceptance by conduct to happen. So, um, parties can argue, oh, we have a contract because everyone knew what the terms were, and we acted like there was a contract, and so clearly there was a contract, and the contract had been formed, and there's law to say that that's a valid contract. It is one of the weakest ways to prove that there is a contract, by saying, "Oh, we didn't sign anything, but we had acceptance by conduct." And so these browser app terms and conditions that you sometimes see on the internet, there's a lot of law in the UK suggesting that if you actually tried to use them against someone, they wouldn't really work. So if you have important contracts and you want to say stuff like, accessing working with me means you agree to these terms, it would be risky to rely on that. And again, lawyers will always just at least get a positive affirmation somewhere, and best practice is to get a signature. Um, so yeah, all coming back to we don't need things in writing, but the more certainty we have, the better. Now, as mentioned before, when you're handed a legal document, it's important not to look at it like a blog post or a book, but look at it as a structured document with sections. And usually a contract, and there's no law around this, it's just convention. Contracts are structured in a particular way. We have the parties at the beginning, we have the definitions at the beginning or at the end. Sometimes we have a background section, which is a section that, if it's a long contract, lawyers will often say, this contract is about XYZ, and give a couple of paragraph summary as to what's going on. Usually it's not part of the legal terms, just to make it easy to know what's happening. Then we have the terms section, and yeah, at the end we'll have the signatures and the schedules. Although sometimes people have the schedule, which they'll call an order form, at the front of the agreement, and that's where all the commercial pricing and terms go. So it's played around with a little bit, but usually it's structured in this kind of way. So you're flicking between the top to see who it's with, and sometimes the end to see what the definitions are. And then inside this term section, which is obviously the largest section of a contract, there's also conventions in terms of how those things are ordered. And again, not necessarily it has to be this way. It's just conventional. And so in a service agreement, for example, or in most agreements, you'll normally begin with the duration. When does this agreement start? When does it end? You'll start talking about what person A and B are doing. Towards the back, you'll have termination. In the middle, you'll talk about confidentiality and liability if something goes wrong. An employment contract, which is a very different document, still loosely will have the same structure. We'll have the when it starts and ends at the top, and how to get out of it towards the end, and what people are doing kind of towards the beginning, and confidentially and IP towards the end. And then pretty much all of them will have this section that lawyers call boilerplate clauses. And these are just formalities that help make the contract enforceable. They'll say, if there is a dispute under this agreement, it's governed by the laws of England and Wales. If one person wants to terminate or send any other message to someone under this agreement, for it to be counted as a valid message, they must email this email address or send this letter to this address. If parties want to change, or if one of the parties is acquired as a business, here's how it works. So all of these kind of conventions that might apply to all agreements are often covered at the very end. So again, if I'm handed a contract and somebody says to me, hey, here's this contract, how do I get out of it? I will sort of flip towards the end and look for the termination clause first and be able to read that. So again, if you once you get familiar with reading contracts, you'll start to see these different sections in the different agreements that you're looking at, and kind of know where to look. One of the very, very important things to understand, and this is something a lot of small businesses get wrong, is understanding that whether a contract is good or bad depends heavily on which party you are to the agreement. So, for example, a service agreement, which is a very common agreement for businesses. If you're a service provider, you might call this your client agreement, your client terms and conditions, but whatever the agreement is that you have with your clients, there's, as I mentioned, those different sections. When does it start? When does it end? What's each party doing? How does it end? What's the liability position? within each clause, the way it's written can it's not just good or bad. I mean, it could just be really bad if it's written in absolute gibberish, but usually for a lawyer to tell you whether it's a good or a bad clause, it depends on who you are. There's a clause that could be amazing for a client, but terrible for a service provider, or vice versa. Same with payment. If it's certain types of payment clauses could be really bad for the client and very good for the service provider, and so on with intellectual property and liability and termination. So one mistake we see a lot of small businesses make, they'll either download or try and create their own template document, and they'll use it with their clients. Maybe it's never been checked by a lawyer. And they're signing these contracts, and actually it might be a service agreement, but it might be a client-friendly service agreement. So it's really terrible for them, and actually puts them in a worse position than if they didn't even have an agreement at all. So um, if you're thinking, oh, I just need a service agreement template, let me just find one online, or do it myself or copy someone else's. You just got to be really careful that it's actually one that's balanced in your favor. And every time a lawyer is reviewing a contract, which we frequently do for our clients, we'll always, every paragraph that we're reading, we're thinking of it from our client's perspective. Okay, my client is the service provider here. So I want to make sure that they're going to get paid on time. I want to make sure they're not over-promising on what they're going to deliver. I want to make sure they've got flexibility to do things with other clients. I want to make sure if something goes wrong, they're not going to be sued massively by the client. But if I'm acting for the client, I'll think, well, I don't want to part with my client's money until I'm sure that we got what we paid for. And I just want to make sure that my service provider is not taking my confidential information and sharing it with all kinds of other people. And if my service provider does a really bad job, well, I'm going to want at least a refund. And if they seriously damage my business, I might want some more compensation. So completely different analyses based on who you are in an agreement. And the wording of a clause can be very different. And we will just now kind of go through um, a bunch of examples of those sorts of things. So, for example, this is a payment terms clause. This would exist, for example, in a service agreement. So people may have seen clauses like this. The client agrees to pay the full amount upfront with deliverables to be provided as per the service provider's discretion. So this is an example clause where a payment clause, which is really bad for the client and very good for the service provider. The client's basically agreeing to give, this is a very basic example, the client's basically agreeing to give this service provider all the money, and the service provider can just deliver what they want to deliver. And again, let's use a website example. The client pays a website designer to design their website, pays them the £10,000, and then the web site designer says thank you, takes 6 months and delivers a terrible website. The client's already parted with their money. This is a bad deal. So for the client, it's amazing for the service provider, but it's very bad for the client. So you can see the issues here, which are fairly obvious. It's not clear what they're actually getting. They're having to part with all their money up front, which puts it on them to get the money back if something's wrong. And the service provider, under this contract, gets to decide when the job is done in their opinion, rather than the client being able to say, well, I'm not happy with that. So a better version of this clause would look like this. The client agrees to pay 50% upfront with the remaining balance due upon delivery of all agreed deliverables. So we've got a capital D there for deliverables, and presumably there would be a definition of deliverables, which makes it quite clear what the client's going to get. The client has only parted with 50% payment. The other 50% will be paid for at the end. So it reduces the risk for the client. And it actually will result in a better service, because the service provider knows I'm not going to get my remaining 50% payment unless I do a really good job and until I've delivered the deliverables at a quality that the client's happy with. So these are basic examples, but when you're looking at these payment clauses, you always want to be thinking, if you're the client, how much risk am I undertaking in the way that this is structured, and can I change the way that the payment clause works? And similarly, if you are the service provider, you want to get as much payment security up front and as well. And this is often a good compromise position. You hear about the 50-50 payment structure where both parties end up relatively well protected. Another example clause is the ambiguous scope. The service provider will deliver services as necessary to fulfill the project requirements. This is a surprisingly common clause that we see in service provider agreements. For those of you who have engaged service providers, oftentimes they'll hand you their contract and you might just be signing it without looking at it very closely. Oftentimes it will say things like this, we will deliver the services and you'll have to take them as they are. And we will decide when the project requirements are met. So this one is sort of unclear. It's unclear what the project requirements are. It might increase a dispute. I thought the requirements were this, but you thought the requirements were that, and there's nothing in the contract to guide on exactly what's included. I mean, a clause like this is I think bad for both parties because the service provider could do what they think is a really good job, but the client may be unhappy, and then be shifting the requirements. So much better is to be more specific. And this is where these schedules can come in. The provider will deliver the services outlined in Schedule A within the agreed project scope and timeline. So we have, for example, an example scope that Sprintlaw might provide for a company registration service where it's quite clear what is included in the fixed fee scope. You'll be paying an amount and you'll get a consultation. This application will be completed and you'll get a pack of documents. The more specific that you can be, the better. This one, it doesn't specify how long the consultation is. So there could be some dispute about that. What does consultation mean? It doesn't specify everything that's in the company register pack, so it could be improved by explaining exactly what's in there. Of course, you have to balance too much specificity with brevity and it being a nice experience for your clients if you're a service provider. But the more specific, the better. It helps prevent scope creep. People know what they're paying for. It reduces misunderstandings. Having detail in a schedule, as I said earlier, can make things really clear, so you don't have to have it buried in a terms and conditions. But managing scope for anyone working with or who is a service provider is one of the most effective things you can do to make your business run better. And again, it can be handled a lot through contract drafting. And again, on the other hand, if you're a client, it can be a big red flag if it's not clear what you're getting for what you pay for. So I think this is important. I mean, for Sprintlaw, we are a service provider, and we've been doing what we do for nearly 10 years, and over time, our scopes and the specificity of our scopes have evolved considerably. And I would encourage people who are service providers to do the same thing. Don't just stick with the first version of your contract. Each time you have recurring issues with clients where the scope gets out of control or something wasn't clear or there was a misunderstanding, go back and think about making it more and more clear in your scope of work at the beginning. And over time, you find that the experience is better for everyone. Clients are often have a much better experience when they were told up front what was included and what wasn't included, and don't react well if something was vague and there's a misunderstanding. So a lot of things can be avoided with clear scopes of work. Intellectual property, another clause that comes up a lot in contracts. This is a version that's bad for a client. All services and deliverables developed during the term shall be owned by the provider, and nothing in this agreement shall transfer any intellectual property rights to the client. So let's imagine, I'll just continue with the web developer example because it's a simple one to understand. A client engages a web developer to design their website. The web developer designs the website. The client pays them the money. Under this clause, the website developer owns the client's website. So if the client decides to stop working with their website developer, they could say, well, you can't use the website anymore, which would be obviously terrible. The service provider is also free to go make the exact same website or reuse components of it with other clients. And so the client might end up thinking they have their own website, but it's identical to 10 other people's websites. So making sure it's clear that who owns the intellectual property um, is um, is really important. Now, if you are the service provider and you are a web designer, you may want flexibility to reuse aspects of what you do for client A for clients B, C, D, E, F, and G. It may be a really important part of your business, and how you're efficient is that you're able to reuse things. So you may want to, but you don't want to end up in a situation where your client didn't know that and then is complaining, or they've agreed to terms and conditions where technically it's theirs. So this clause can be really quite important. And in this case, it's not clear exactly how it works, but it looks like the provider is going to sort of own everything. So a more common clause that you see with intellectual property ownership: any intellectual property created specifically for the client under this agreement will be owned by the client, but the provider retains ownership of any pre-existing IP. And we have a defined term here, capital PEIP, used in creating the deliverables. This is a very common middle ground clause for intellectual property ownership, and essentially says any stuff that I, the service provider, had before I started working with you will still be mine, and I'm going to be able to use it with other people because I had it before I was working with you. Any stuff that we work on together will be yours. And that helps make it a bit clearer as to who owns what and who can do what. And of course, it rests on a clear definition of pre-existing IP. What is the stuff, which the provider will usually list in general or specific terms, what they owned before, and what are the deliverables. So what's the stuff that's going to have that client ownership. So you can see again, the clarity can be much better for the client and really for both parties for clarity. GDPR and privacy clauses are another very important clause, which can be drafted in ways that are very bad for the client or good for the client. This is an example of one where you've engaged a service provider and they've said the provider may process client data as required to deliver the services for internal business purposes. So you are giving your service provider information. Maybe it's about your business, maybe it's about your own client's business. And the service provider is saying they will do vague things with it. We don't know exactly what they're going to do. They're going to use it as required to deliver the services and for internal business purposes. Are they going to just use all the data you share with them for analytics, for marketing, for sharing with third parties? Very unclear. It's not clear who is the data controller or processor. Without going into great detail under the GDPR, usually, or it's usually required in arrangements where one party is sharing data with another party, for it to be clear as to who is the data controller, so the person that controls the data, and who is the data processor, the person that's merely processing it or handling it under the instruction of the data controller. And they have different requirements at law. So, for example, if you use a CRM system like Salesforce or Pipedrive, you are populating that software with all of your clients' data. So you are the data controller, but the software and their IT team have some access to all that data too. But they're just processing it or handling it under your instruction. So they'd be considered a data processor. And again, defining those parties matters because there's different GDPR obligations for each of them. And this clause doesn't even do that at all. It's not clear who is the data controller or processor. And again, there's not any safeguards. So, you, the client, is sharing all this stuff with this provider. They don't promise to protect it from, risk or harm. And so again, not very good for the client. A better version of the clause would be the provider shall only process personal data as a data processor on the client's documented instructions. So you, the client, are the controller, and I'll only use this data in the way that you tell me to. And it will only be used for the purposes of providing services to you, and will have appropriate technical and organizational safeguards to protect your data as outlined in Annex 1 or Schedule 1. And that would often be a list of all of the great security requirements they have. So this is a much better GDPR clause. It's clear who the processor is. The client gets comfort that the service provider is going to protect the information and not use it for other purposes. And again, if you are engaging a service provider, you want to make sure you have agreements like this to the extent they're going to have access to your client's data or your data. And And again, if you're a provider, you want to make sure that you're able to comply with these clauses, of course, if you're putting them in the agreements. Renewals and termination clauses. These are very important clauses. One of the first things I learned many years ago as a young lawyer from a very experienced contract lawyer. He said, Alex, if you are given a contract and you only have time to review one clause, look at the termination clause. And I said, why? He said, well, you need to know if you can get out of it, if it's a bad deal. And I think that's important to remember. If we think about that risk matrix I shared earlier, uh, uh, for the level of risk a contract may involve can depend heavily on how long term it is. If you're agreeing for a contract for just a month, well, it's not the stakes aren't that high. But if it could be a long term annual renewing thing that has big cancellation fees and so on, now we have a situation where the stakes are a little bit higher. Um, so this is an example of a clause that's pretty good for a service provider, not very good for a client. This contract will automatically renew for an additional year unless either party provides 90 days of written notice before the expiration date. So this is what we what lawyers call a subscription trap, and it's very common in service provider arrangements where you'll sign up for a contract that renews annually, and it will automatically renew unless 3 months before the end date, you remember that to tell them that you don't want to renew. So you got to remember at the 9 month mark, which is very non-intuitive, often buried in the fine print. And then you try and cancel a week before renewal, and they say, well, you didn't give us 90 days notice. So now you've got to renew for a year or pay a cancellation fee. So a fairly extreme example, but there's less extreme version of these that exist. But this clause is obviously nice for the service provider. They're going to lock in their revenue, although they're likely to have some angry clients on their hands. But for the client, very risky. So the better version for the client of this clause would be the contract may be reviewed annually by mutual agreement. We have to both agree to it, and either party may terminate with 30 days written notice prior to renewal. So a 1 month notice period if they cancel before the renewal date, and they have to both agree that they want it to renew for another year is obviously much better for the client. Liability clauses are also critically important in most commercial contracts. These are contracts that these are clauses that specify what happens if something goes wrong. What happens if the service provider does something wrong, the client suffers loss, and they want to make a claim against the service provider? How's it going to work? This is an example of a version that's very good for the client, but very bad for the service provider. And if you're a service provider, you want to make sure you don't have clauses like this in your client agreements unless you absolutely have to. This says the provider agrees to indemnify the client for any and all claims, damages, or losses arising from the use of services or deliverables. So indemnify, for those that don't know what that term means, basically means an agreement to cover all the losses that the client suffers in this case. I will indemnify you. I will cover all of your losses, is what that means. And again, to use an example of a website designer, if you are the website designer, you design a website for a client, they pay you £5,000. 6 months later, there's a bug on the website. The website goes down for 2 months. It's a very large client. They're not able to accept orders for 2 months. They lose hundreds of thousands of pounds, and they come back and they sue the provider and say, you have to pay us £200,000 of our losses because you agreed to indemnify us from any claims arising from the use of or losses arising from the use of service. We used your website. We went down. We lost a lot of money. And even though we only paid you £5,000, you got to cover us for all these losses. Now, that is how it would work if that was the wording in the agreement. This is very risky for the service provider to agree to. Much better is to have a improved and more balanced version of the indemnity and liability clause. So both parties agree to cover each other, indemnify each other against claims arising from their breach of confidentiality or breach of laws. So this is fine, we'll cover each other if there's a serious breach of confidentiality or someone's actually broken the law. But in all other cases, it's saying the maximum liability of either party under this agreement is limited to the fees paid by the client to the service provider in the preceding 6 months. So what that means is unless somebody does something really bad, the most that the service provider could be sued for is a refund of 6 months fees. So in the example I gave earlier, if all that had been paid was the £5,000, it would be, doesn't matter that the client's lost £200,000, it's just a 5K liability to the service provider. So it makes a massive difference to have the liability cap. Now there's this section at the end which says, except for liability arising from death or personal injury caused by negligent fraud or fraudulent misrepresentation, breach of implied statutory terms as to title or any other liability that cannot be legally limited or excluded. That bit of legal jargon is a requirement of English law that says, okay, we will allow in private contracts people to limit their liability and say, I will only let you sue me for this. We're going to respect that unless it's in one of these cases, it's caused someone's death or fraud has happened, etc. So again, it's a similar concept to this stuff. If it's a really serious case, the service provider cannot limit their liability. So there are legal boundaries on what you can do in these liability clauses. But within those boundaries, if you're a service provider, you really want to make sure you've locked down your liability. And we've had many cases of clients. There's a client we had several years ago who has allowed me to share this story because I think it's a great illustrative example. Was doing digital marketing services for one of their clients. They accidentally set their marketing budgets. It was meant to be $50 a day. They set it at an extra zero. It was $500 a day. Nobody realized for a few months it was a large client, and they'd burned through significant amount of the client's marketing budget, and the client tried to commence legal action against them for losses, but they had a good limitation of liability clause that said something to this effect. And what would have otherwise been pretty much business ending for this small business turned out to just be a refund of fees. So there's real examples where these things can save your business, and so that's why I say they're quite important clauses to get right in your documents. That is all of the clauses I wanted to sort of go through. If anyone wants to ask questions, I am very happy to take them. I can see there's one from Olga. So do feel free to drop some questions now if you have any, and I'll answer them. But just wanted to finish by again reminding you of this matrix. If you're wondering if you're handed a contract, when should you get it checked by a lawyer? Just be thinking how important, how high stakes is this agreement? And the higher stakes it is, the more important it is. That's a good time to get it properly checked by a lawyer. And obviously, if it's your Microsoft Office license that you can't really negotiate, maybe that's not worth getting reviewed. But do think of it through this lens, and when it is important, it's very important to get it done right. So Olga has asked question on the liability clause. In your better example, what is the limit for the breach of confidentiality? As a client, you sometimes have to share very sensitive data with the service provider, and it seems a bit risky to limit the claims from data breach to the amount of the service fees. No, I mean what you just said is indeed the point of the wording of this clause. So that is spot on. So normally, in the way this is worded, the general liability of the service provider is the 6-month refund, but this is an exception. It says, well, actually, it's interesting because this clause should be more clearly worded to say subject to the indemnities. The maximum liability of either party under this agreement is limited to the fees paid by the client to the service provider in the preceding 6 months. So it's actually an interesting question because it's the drafting of this is not clear whether the indemnity is an exception to the liability cap or it's subject to the cap. But in usual cases of having an indemnity, usually it's an exception to the cap. So the purpose of this clause would be to say, if you breach confidentiality, I can sue you to infinity. It's unlimited. But in all other cases, it's just the 6 months refund. And that would be if you are a client sharing something with a service provider, sort of exactly as you've raised, Olga, that is how I would be thinking about the liability clause. Oftentimes, I'm handed a clause by a service provider, and they're trying to limit their liability to a refund or a 6 month refund. And I'll say, okay, I'm happy for you to mostly limit your liability for 6 months, but in this particular case, I might be sharing confidential information with you, or I might be asking you to build something that's very important to me, or maybe you're supplying goods to me. And if you're late on those goods, it's a big deal. And I'm paying you a premium to get these goods here on time. So I don't want a 6 month refund. I want an exception to the 6 month refund for serious breaches. And so that's kind of what this clause is there for. So often I will negotiate a liability clause from a service provider and I'll say, I'm happy for you to have your 6 month refund mostly, but I want these 5 exceptions where you're going to fully cover me. And so, yes, that is definitely a good way of reviewing those liability clauses. Okay, that was a good question. Any other questions? Costa said, in the construction industry, it's fairly common for a client to be after the liability being equal to the max PI insurance limit for each and every claim. Is that proportionate for early stage project work, not detailed design or construction, just early stage consultancy? That's a good question. No, usually, I mean, it's specific to the industry, but it's usually not proportionate for early stage consultancy work. It's got a very different risk profile, right? Like construction, if you are actually delivering the construction, there can be serious risks, and so clients understandably want significant protection. But if you are, usually not getting paid as much as the people absorbing that level of liability, it's usual to negotiate those clauses in those circumstances. Yeah, again, it will always depend on exactly what consulting work you're providing, the scale of the project, the dynamics between you and the client, and how much you're getting paid. And it's often negotiated. And oftentimes, consultants will say, if you want me to take on more risk, you're going to have to pay me more. So that's often how it's negotiated. But the short answer to the question is I'd say that's uncommon for the early stage consultancy work. And so if you were in a situation where you wanted to negotiate that, you absolutely should consider doing so. Niles asked, you mentioned terms of service not being good enough, but a lot of clients just want things sorted quickly because their site is broken and needs an urgent fix. What happens then, especially when taking work forward and no MSA and SOW is signed? Look, it's risky. And I think if you are a service provider, I would, depends exactly what you're asking, but I would suggest if you don't have time to get a formal legal contract signed, at minimum, if I was doing quick website or IT work for a client, I would just include on my website a standard terms of service, and at absolute minimum, I would say happy to help. Just so you know, all of this work is covered by my terms of service, and then you link the terms of service, and then you do the work. I've said earlier that's acceptance by conduct. If you did it that way, you would be saying, hey, client, I told you about my terms of service. I never got you to sign anything, but you knew about them, so I'm going to rely on them. But if used in the way I described, it's decently likely to be enforceable. Better would be to get them to sign it. Middle ground would be to get them to accept even a digital quote or a terms and conditions. If you get nothing signed or nothing agreed to, or don't even attach terms of service, there's risk for you because yes, you may sort the thing for the client quickly, but if your fix caused an issue 6 months down the line and they make a claim against you, you don't have your liability protection, you don't have your clarity if they don't pay you on time around payment clauses. So there are ways to, one of the things we often say and work with our clients on is the design of their client agreements, because I said several times it's best to get it in writing legally, but practically for your business, I mean, if you run a cafe, you can't get someone to sign a contract before they drink their coffee and say, I won't be liable if you get burned. It's just not practical to do that. A lawyer might love. I've been to some Mexican restaurants where they made me sign a waiver before I tried the hot chili on the chili wall. So it can be done, but it's practically unusual as much as lawyers would like it. So you've got to think about your business and how it works. And it's a great point that sometimes you can't get them to sign something formal, but something is better than nothing, and there are ways around it. Um, Linda's asked, I have losses of 85K because a solicitor failed to risk assess clauses in the contract. What can I do? Um, well, interesting. I'm sort of reluctant to provide specific advice on a specific case in a public webinar, so I'd probably suggest getting some specific advice on that. I can say in general terms, um, if a service provider is negligent and you can show that they were negligent and losses were incurred as a result of their negligence, you may have a claim against them. Most service providers, including solicitors, have professional indemnity insurance. So their insurer may respond to a claim. And so if it's a significant loss for you, you may wish to get some advice around that. And yes, uh, situations like that, if negligence can be shown, can lead to a claim where your losses could potentially be recouped if you can show that it was indeed due to the negligence and the loss sort of flowed from that. Costas said, if a contract service agreement is signed by an SPV but not the parent company, is it ever enforceable for the parent company? Is a way for a consultancy to protect themselves from limited companies with no trading history? Interesting questions. Uh, the general answer is no. The person who is liable for a contract is the person that signed the agreement. And this technique that you've described is often used as a risk management mechanism for corporate groups. They'll set up a company and they'll sign contracts under that company. And if something goes wrong, in general, the liability is limited to that company. The ways around it is insisting on what's called a parent company guarantee or indemnity from the parent company, whereby you assign the agreement with entity A, the SPV, whatever it is, but you say, hey, I know you're not the parent company. Can you get your parent company to guarantee your obligations? So if you're unable to fulfill them, I have a claim against someone with deeper pockets. Depending on the dynamics, that might be refused, but it is often reasonable to ask for higher stakes jobs. The only other cases are if you can show that the way that the agreement was organized was deceptive and they were trying to deceive you by using the SPV instead of the parent company, or there's some misrepresentation that the SPV is the parent company, but they aren't, and so on. But those are all obviously difficult to argue. So the base case is no, unless you get something signed, and it is very common to ask to get something signed. So again, if it's important, you may want to ask for that. Niall said to follow up, say happy to do it. Here's my terms of service. If you read them and happy to go again, I'll crack on. Then if they want more work done properly, long-term MSA, SOW, I would say, to be clear, I would say that's much better than nothing. What you've written there, that phrase, much better than nothing. Definitely not best practice, because if they argue they missed the email or they couldn't click the link, they never visited the link, you don't have as much evidence. In practice, you'd have a reasonably strong argument if you could show that those things are unlikely to be true. If they reply to the email, if you can show the link was live that day, you'll have reasonable evidence. It's safer to get them to accept something, but yes, that is what I was saying. So with all of those lawyerly disclaimers, hopefully that answers that question. And Linda, you've asked, do you give advice on this? We don't really do, we'll do pre-dispute advice, but we don't really do dispute-oriented legal advice. But if you want to reach out to the team, we have a network of of lawyers and solicitors that may be able to assist with your situation. So do feel free to reach out to us and we can put you in touch with someone. Okay, well, hopefully people found this useful. And we are doing, I think, another webinar in a week or two on employment law changes happening in the UK. And then we've been doing these quarterly, but we may be doing them a bit more frequently in future. So stay tuned. Please feel free to join and get in touch with us if there's anything we can help with. Otherwise, I hope you guys have found this useful and I will see you next time. Thanks.